I'm very pleased to welcome Andrew Harding, who is, well, to say he's no stranger to SOAS, I think it's a bit of an understatement, since he's was here for 17 years, was it? Yes, as a full-time member of staff and also head of the law school and professor of public. Would you say public law? What was your?
Just law, actually.
Just law. Okay. And Andrew, as everybody knows, has written a vast amount of publications on many aspects of Southeast Asian law, particularly an expert on Malaysia and Thailand, and now Myanmar is an interest which he has. I was lucky enough to be able to be involved with the book on Thailand, which we did together, which was a very interesting experience for us both, because we just thought, well, we'll just write this book and it will take a year or two, or it took us 10 years later, something appeared. But since then, Andrew's done a book in our series, the Constitutional Systems of the World Series on Malaysia, and his most recent achievement is a set of essays on Myanmar, which is just about to appear, I believe.
Well, it's just gone into press.
Just gone into press.
Later this year.
So
hopefully.
he's, as always, extraordinarily productive. Anyway, Andrew, I'm going to hand over to you. I believe that after Andrew has spoken for about 35 or 40 minutes, we're going to open up for discussion. And when that happens, I will return. But until then, I'm going to become part of the audience.
So you're moving from my side to their side, is that
That's right.
Okay, well, thank you very much, Peter, and I can't tell you what a huge pleasure it is to be back at SOAS and seeing so many familiar old faces and some new faces, and thank you all very much for coming along. This is sort of pretty terrifying, because I realise that between you probably all know about 5 times as much about this subject of human rights in Thailand as I do, but hopefully I can at least provoke some sort of discussion. I did spend recently a month in Bangkok and spoke to people there about a lot of the issues that I want to briefly mention. But it's not my intention actually to address the current situation in particular, but rather to take a sort of a longer view of the human rights situation in Thailand. So, I mean, the title is Human Rights in Thailand, a Failed Transplant. So, I'm going to come down at the end to try and answer that question. Is it first of all a transplant, and if so, is it a failed transplant, or is there a sort of room for development in this area? So, this is basically the agenda, to go through the origins and the history, major human rights markers over a span of 80 years or so in terms of constitutionalism in Thailand. And then we'll look at the Bill of Rights, the latest one in the 2007 Constitution, and importantly, I think the institutional mechanisms that are there to promote and deliver human rights, followed by the actual performance of those institutions and the way in which the Human Rights Project seems to have been failing in the last few years after a promising start. So these are just some images to show you that human rights do have some resonance in Thai society. This is not a completely sort of strange or unusual idea. So you've got people protesting about disappearances, about police process, about the war on drugs and so on. So what I wanted to sort of first of all stress is that when you look at what's actually happened in Thai history over a period of, well, actually much more than 80 years, you find that there has been maybe not an overt discourse around human rights, but at least an understanding of what human rights might involve. I mean, if you go back to the 19th century and the legal reforms that were started by King Mongkut and then completed by King Chulalongkorn. You see elements of religious freedom, freedom of marriage, abolition of slavery. King Mongkut famously had many wives, so that any of them were free to leave at any moment because there was no compulsion in marriage. And he and King Chulalongkorn gradually, over a period of time, abolished slavery and so on. Although sometimes when you're in Bangkok, you can see some pretty overt slavery going on, according to modern definitions. So in 1932, the first constitution was drafted by Prithee Banumyong, and therefore, it was obligatory to provide some sort of a basic bill of rights, and actually that was one of, if not the first bill of rights in a constitution in the whole of Asia. So it's a notable first, and one implication of this that I always like to mention is that the constitution involved giving votes to women as well as men, of course. And actually the UK itself only gave women votes on the same basis as men in 1928. So Thailand was actually only 4 years behind this country in terms of equal franchise for men and women. I think this is a useful kind of reminder. Well, most of you will know a lot about the subsequent history, and in particular in the context of human rights, the army brutality against protesters, particularly in 1976 and then 1992. And having just spent a month on campus at Thammasat University, it's actually very moving and significant to see the number of commemorations of the human rights abuses that took place on that very campus. There's a very strong institutional awareness at Thammasat and of course elsewhere in Thailand of the importance of these issues, and that obviously created a kind of a demand for human rights that you see coming out in the 1997 constitution, the so-called People's Constitution. Signing of the ICCPR in 1996, 1997 constitution with its extensive human rights provisions, with also, interestingly, restrictions on their abridgment, because typically what you get with these provisions, you get a right and then you get the circumstances in which the right can be denied, and inevitably it's giving with one hand and taking away with the other. But the last two major Thai constitutions have actually imposed restrictions on the restrictions, which is a really important point if you want to make sure that rights actually mean something rather than just being taken away by legislation and executive action and so on. So the important thing here, I think, is the creation of the Constitutional Court. We'll come back to that a bit later on, which started work in 1998, and also the creation of the National Human Rights Commission. I'll come back to that as well, which started in 2002. Both of those were mandated by the Constitution, and both of those seem to have been entrenched in constitutionalism generally in Thailand, because there's not been any real suggestion about doing away with those institutions. People have criticized them endlessly, both of them, but nobody suggested doing away with them. Now, with regard to the Human Rights Commission, which started in 2003, I remember very clearly, it was April 2003, I had a conversation in this very building with Professor Sane Chamarik, who was the first chair of the Human Rights Commission. And I put to him what I thought was a pretty interesting question. Given that the 1997 Constitution has got this splendid array of rights, it's almost state-of-the-art fundamental rights provisions, I note, I said, Professor Chamarik, that none of this seems to have anything particularly to do with Thailand. I mean, everything is just sort of lifted from general notions from international law, from other constitutions and so on. I don't see anything Buddhist or Thai or related to Thai experience or whatsoever in this Bill of Rights. So how do you propose to deal with that under the Human Rights Commission? His answer was very interesting. He said, well, we will use Buddhism as a bridge for this gap between what the Constitution says and what people's understanding of human rights might be. And I think, at least at the start, I'm not quite sure about now, but at least at the start, this is indeed how they tried to sort of educate people, particularly in rural communities, about human rights. So then the International Covenant on Economic, Social and Cultural Rights, the NHRC, started work. And then, as you know, the coup of 2006 brought an end to the 1997 Constitution. The Constitution of 2007 was then drafted, and interestingly enough, it actually expanded human rights, not only in terms of the substance of the rights, but also in the institutional mechanisms to support them. In particular, for example, the 2007 Constitution allowed citizens of individual rights to petition the Constitutional Court on a matter relating to fundamental rights, whereas previously only officials named in the Constitution could bring a case directly to the Constitutional Court. So this is basically about the provisions in the 2007 Constitution. So, regard shall be had to human dignity, rights and liberties by all state organs, and those rights shall be binding on them. And I think, very interestingly here, indicating seriousness about actually delivering these rights is Section 28, which allowed expressly an individual to bring a lawsuit or to defend him or herself in the courts based on the rights and liberties in the Constitution, and even have a right to be enhanced, supported and assisted by the state in exercising of a fundamental right. So this is clearly an attempt to make human rights kind of a practical reality rather than simply an aspiration, because you don't have to have a provision like that. Very few constitutions actually do have such strong provisions about access to justice in the context of fundamental rights. And then, as I pointed out earlier, there were restrictions on the restrictions. Restrictions of the rights in the Constitution, can only be imposed by a law specifically enacted for the purpose determined by this Constitution, and only to the extent of necessity, and provided that it shall not affect the essential substances of such rights and liberties. So those three very important, restrictions on the restrictions on human rights, which I think are very sort of positive development. It sort of brings in mind, in a way, when it talks about essential substance of rights and liberties, the Indian position with the basic structure of the Constitution that cannot be violated even by a constitutional amendment. So it's a slightly similar kind of idea. So I don't want to talk really about individual rights because there are too many of them, and there's not enough time to do that. But this slide basically so I think gives you the idea that the fundamental rights really do cover very broad areas. I mean, including in education, welfare rights, right to information, and so on. So it goes way beyond the standard Bill of Rights in terms of what it actually covers. And I've put there section 66 because when I had that conversation with Professor Sane in 2003, he mentioned this provision, or rather its predecessor in 1997, as an example of how the Constitution drafters had responded to something that was uniquely or locally Thai. So here it talks about traditional communities and maintaining their culture and so on in this provision. So he said, it's not all just lifted from other constitutions or the International Bill of Rights. This is something where we've actually responded to a real live issue that is there in Thailand, particularly, as you know, in the north of Thailand. So these are the sort of resources you might think about in terms of what is available in terms of human rights. You've got the extensive Bill of Rights it says itself, but obviously you have to go further than that if you want. I think everybody recognizes since the Vienna Conference in 1993 that you need to do a lot more than simply rely on the law to enforce human rights. So now, under the 2007 Constitution, you don't need any implementing legislation. The rights are, in a juridical sense, are self-enforcing. It's not simply an aspiration. You can use those rights juridically in a case, whether you're suing the government or whether you're defending yourself against a criminal charge, for example. And then, of course, you've got the Constitutional Court itself, which largely originally entertained human rights cases due to the Ombudsman bringing cases before them. Now they can be brought by individual petition. I will come down a little bit later on to say that I'm not really that impressed by the performance of the Constitutional Court in this particular aspect. But as is typical these days in constitutional law, you can also refer a case, even in the ordinary civil or criminal courts, to the Constitutional Court if a constitutional issue involving fundamental rights arises during the course of the case. Embraced by the administrative court system, because the administrative courts are much more at the sharp end of what happens. The Constitutional Court is basically, in this context, is only there to consider the constitutional validity of legislation, whereas the administrative courts can deal with executive action. So in a day-to-day way, the administrative courts have been much more engaged with fundamental rights than the Constitutional Court has. Now, if you're interested, I was actually visiting the administrative court in Bangkok just the other day, the Supreme Administrative Court. And I was impressed by the buzz of activity in the building. I mean, even though Thailand is under military rule, it has not affected the very large numbers of people turning up to file petitions in the administrative court system. So that system seems to be working quite well. Not sure one could say the same about the other mechanisms that are there to take this forward. So, okay, we've got the Human Rights Commission itself, the People's Petition for the passing of a law. So if you can get 50,000 signatures, then you can petition Parliament to pass a law on a particular issue. Freedom of information law has come into effect, and information is very important in the context of fundamental rights. There are plenty of public participation provisions in these various constitutions. I know we don't have one at the moment, but that's the prevailing ethos in Thai constitutional law, is you have to have lots of public participation, and legislation routinely provides for public participation in making major decisions. And civil society activism and self-help has been growing very rapidly over the last 20 years or so. It would be nice to add to that there is a progressive and active bar that takes up these cases. That's really not quite the case at the moment, although there are public interest lawyers. So cases, well, it's a very mixed picture. If you look at, this is all covered in chapter 5 of the book that Peter and I did, where that discussion is a little bit out of date now, but there haven't been too many cases on fundamental rights since we wrote that. I'll just mention one here, or maybe two. The disabled lawyers cases. A couple of cases brought by people who were disabled and had applied for positions as a prosecutor or a judge. And they were rejected on the basis that they were disabled. And yet the Constitution said quite clearly, 1997 Constitution, the same provision appears in 2007 version, that you cannot discriminate against anybody on grounds of their health condition. It looks like a completely open and shut case. How can you discriminate on grounds of disability when the Constitution says that? But anyway, the court managed to find a way of upholding the regulation that said that this was a criterion for the appointment of prosecutors and judges, and said that Thai society was not yet ready to have disabled judges and prosecutors. I find that whole reasoning just totally absurd. And why have constitutional rights if you're going to deny them in the most open and shut case that you could possibly imagine? Similar thing happened with the case involving the Buddhist monk who was a member of one of the local authorities and was turned off membership of the authority on the grounds that the law said that a monk cannot be engaged in mundane activities such as being a member of a local authority, and he challenged the constitutionality of this in the Constitutional Court, saying that this was discrimination on the ground of religion, because if he had been a Catholic priest or a monk or a Muslim imam, there wouldn't have been any problem whatsoever. But again, the court went back to Thai legal traditions and the importance of Buddhism in Thai society, and upheld the statute that prevented him from participating in local authority activity. Well, we could go on, and not all the cases are bad. I mean, the married women's surname case is quite a good one, where they said that a law that requires a woman to take her husband's surname cannot be constitutionally valid because it's gender consideration. So sometimes they get it right, but not as often as one would like. So let's talk a little bit about the Human Rights Commission. And as you can see from the logos, this idea of having a national institution for human rights has spread right across Asia, most recently in Myanmar. They put the Human Rights Commission on a statutory basis. This has been a little bit controversial, but that's not untypical of human rights commissions right across Asia, where there have always been controversies about their powers, about their composition, about who decides who shall be members and what sort of people you should have and what sort of activities they should undertake and so on. So this is the current version of composition of the Human Rights Commission, and in fact they have appointments for 6 years, and 7 new commissioners were appointed, quite controversially, in 2015. We'll come back to the controversy in a moment. And basically what is set out in the slide is a system for appointing members of the Human Rights Commission that is pretty much exactly the same as the system for appointing members of any of the independent agencies, such as the Anti-Corruption Commission, the Ombudsman, and the Election Commission, and so on and so forth. So the idea is that you have a selection committee whose independence itself is guaranteed by the Constitution prescribing who the members of the selection committee will be. So in theory, with a system of this kind, then you should be able to ensure that the process is independent. Quite notably, in the 2007 Constitution, these selection committees have control ultimately over the appointments. Previously, they could make nominations to the Senate of twice the number of people that were required. So if you needed 7 human rights commissioners, you nominated 14 people and the Senate got to decide. The Senate now can feed back to the selection committee, but ultimately the selection committee can override the Senate and has a veto over them on this issue. There is now under the under the 2007 Constitution, there was a narrower sort of drawn selection committee. This is now all governed by statute under the current constitutional situation, but notably with no civil society representation on the selection committee, and that's a bit of a problem, as was then pointed out by Human Rights Watch when the new commissioners were appointed in 2015, saying basically that only one of the 7 commissioners had any experience in human rights, and another one had been less than supportive of human rights in public. Actually, looking at the members who were appointed, I don't quite agree with this assessment. I think it's a little harsh, because it's true that only one of the commissioners could be described as a human rights activist, and this is very interesting. Ankana Nilapayjit is actually the widow of Somchai Nilapayjit, who was the Muslim human rights lawyer who went missing during the Southern insurgency episode in 2005 and is presumed to have been murdered by the police or the military. And so it's his widow who is obviously fingered by Human Rights Watch as the right kind of human rights commissioner. But you know, you don't have to be a human rights activist to be an expert on human rights. And actually, some of the other commissioners do have extensive experience in relation to you know, health and women's issues and children's issues and that sort of thing. So it's a little bit unfair to paint it in that way. But at the same time, when you look at their profiles, they are very much sort of elite-oriented people. And that's always a struggle when you have a human rights commission, because the civil society wants it all to be entirely consisting of civil society people, and the government wants people who are members of the elite, and you always have this sort of to and fro over the members of the commission. So this is basically just dealing with their powers, which are fairly typical and fairly broad in terms of what you find with human rights commissions across the world and in Asia. There is often, I think, a misunderstanding about the role of these commissions, because they don't really have judicial or executive or legislative powers. They are there to educate, advise, facilitate, train, investigate, report, highlight, and all of those things. But ultimately, the responsibility devolves onto the agency that is responsible for the particular function, whether it's the military or it's the police or it's a government ministry or local authority or whatever it is. And so inevitably you get this sort of cry that, you know, we created a Human Rights Commission and they did nothing. Actually, when you look, they actually do quite a lot, and the Thai Commission has not been inactive. But you can't expect a Human Rights Commission simply to deliver human rights justice, because that's not quite how their function should be properly perceived, I suggest. But at least it continues, and it is operative, even though we may criticise some of those things. So, so what have been the issues? I mean, obviously at the moment there are concerns about fundamental rights in Thailand, principally in the area of civil liberties, freedom of expression, freedom of assembly, freedom of association, you know, are problematical at the present time. But I think it would be a mistake to equate entirely military government with human rights abuses, because actually, if you look at the abuses that have taken place, most of them have taken place under you know, civilian elected governments, not under military governments. I don't want to let the military off in this sense, but the worst instances have actually been under elected democratic governments. For example, the war on drugs, and there was a picture of that earlier on, protests about that, in which something like 2,500 people were killed by the police and the military without any process of law. It's a very shocking process that went on for a couple of years. And it was explained in terms of, you know, he resisted arrest, or he suddenly jumped out of a window when he was in police custody. These sort of explanations were given. But the best assessment is that really these people were bumped off by people in authority without any proper process of law, on the express authority of the government and the then Prime Minister Thaksin at the time. Round about the same time, terrible human rights abuses in the south of Thailand with the insurgency and the overreaction by the government and the military, especially under the emergency decree of 2005. And then we could talk about the crackdown in Bangkok in 2010 with the red shirt protests, which were brutally you know, dissolved by the police and the military. Issues generally to do with citizenship involving indigenous communities in the north of Thailand, and in particular refugees from Myanmar. Very famously, of course, the Les Majestés cases, which have increased in number in recent years and have given rise to concern about the effect of those cases on freedom of expression in particular. And more generally, limitations on freedom of expression, assembly and association, especially since the coup in 2014. Now this shows, I mean, some of you will know what this is about. This is the dispute, the problem over the appointment of the new Buddhist patriarch in Thailand, which has been quite contentious and resulted in a protest by some monks about the way in which this was being handled by the government, and in particular by the ombudsman who made a ruling in relation to this matter. So there are sensitive and difficult issues right now in Thailand about the relationship between the state and the Buddhist Sangha. And this is really what is underneath this. So the other day, I mean literally only about a month ago, we saw the extraordinary sight of a monk being arrested and being taken off, as they can do under emergency military decrees, to have his attitude adjusted by the military. So this is the phrase that is now used, is attitude adjustment. And so, I was asking people, well, how do you adjust the attitude of a monk? Do you ask him to shave his head and meditate, or because that's what they do normally anyway? Very bizarre to see soldiers adjusting the attitudes of monks rather than the other way around. Now, this is interesting, because in my conversations in Bangkok, I was trying to get to the might be quite long. How did this work? Well, in practice, it works at two different levels. There is another process which is much less severe than having your attitude adjusted, which is called being invited for a cup of tea. And so you literally get invited for a cup of tea by military officers, and it's all very polite and very friendly and reasonable, but they make it clear that you are being watched, and you're okay at the moment, but if you go any further, then the strong hint is then you might need to have your attitude adjusted, which is a much more serious thing. So this was described to me by somebody who participated in one of these things, actually a former student of mine in Chiang Mai, as a very civilized process. We were invited to go along with our colleague. You can take your friends with you and sit round a table and have a general discussion about the condition of Thailand, and you have your cup of tea. But there is this sort of implication that it could get more serious. Many of you will know about the case of Professor Warajek, for example, who sort of was out of the country when he was asked to go and talk to the military, and sent his wife instead. And it was all sorted out in the end, but it was kind of a nasty episode in terms of the implications for freedom of expression and civil liberties. And then there was an amusing case of Dr. Pavin, who will be known to many of you, I think, in the room, who was in Japan when he was called up, and he said he would not go and see the military, but he would be happy to send his pet Chihuahua in his place, which no doubt postponed his return to Thailand by quite a considerable period of time. So that's the situation at the moment. These detentions are very worrying. I wonder whether this is actually worse or better than what happened in 2006, 2007. Where there was also a very strong crackdown on freedom of expression. My feeling is that this is actually slightly less threatening than what happened 10 years ago, but I'm open to suggestions to the contrary, if you have different assessments of that. So it's not a great situation. So, all right, this is my question. Is this a failed transplant? Well, I think basically this is transplanted law. I think that I've given you one exception, I think, to that idea. But I think basically, in terms of constitution drafting, the concern is really to sort of be seen to comply with the International Bill of Rights. it doesn't explain all of the provisions, because some of them seem to be a little bit autobiographical in terms of being responses to things that have actually happened in Thailand. An example is the provisions about media ownership, which I don't think there's any provision in international law that requires you to prevent one person from owning most of the media. But if you're in Thailand, that seems a good idea, because Thaksin owned most of the media and sort of used that as a very powerful political weapon when he was prime minister. So that's, it doesn't explain everything, but it explains most of it. You cannot really find, otherwise much that is based on Thai, philosophy, religion, or social mores. There's not really much there. Is it successful? Well, basically, no, I don't think it has been a successful transplant. And not just because right now there is no fundamental rights, Bill of Rights with a constitution that is in force. I mean, that will happen in due course, and it will be interesting to see where they go with the fundamental rights project. Will they, repeat what happened in 1997, 2007, or will they try and find some sort of halfway house? My guess would be that there will be rights in the constitution, there will be strong restrictions, and probably they will do away with the restrictions on the restrictions, leaving fundamental rights very exposed probably in the next stage of development. But we come down to this problem that it relates to every issue that we discuss in terms of constitutions and the law in Thailand, which is the oscillation between the democratic constitution and the Praetorian rule that we get from time to time. And this oscillation has been going on basically since 1932. And it seems to be very difficult to find a way out of this kind of vicious circle that just keeps happening. And I'm certainly not confident that General Prayut has the answer to this particular question. But my point here is that this profoundly affects both the definition and the practical delivery and observance of human rights. So 40 years after the Thammasat University massacre, human rights are still not entrenched in Thailand, but one can argue that some progress has been made nonetheless. The Human Rights Commission seems to be here to stay. The administrative courts at some level, have been successful in making some pretty good decisions on some issues. There's even a decision by the Intellectual Property Court that is based on fundamental rights, which is a bit promising. The development of civil society, the attention that is given in detail to the Bill of Rights itself, which is an indispensable foundation even if it's not sufficient, and a general rights consciousness. And there has been research on the issue of legal consciousness in Thailand. It seems to indicate that this is on the increase, particularly in the rural areas where it's not been very much present in the past. So I would qualify a little bit my negative conclusion by saying that perhaps it's too early to give a final verdict on the entrenchment of fundamental rights in Thailand. But at this point, it does look rather like a failed transplant.
Thank you. Thank you.